So, for those of you who I haven't met, my name is Ella. I am a commercial associate at White and Black, and we are a law firm who we specialise in commercial law, and we try to give advice that is focused on commercial objectives, challenges and opportunities. We want to make things work for our clients. We're not just there to say you can't do stuff. We know that legal questions don't exist in a vacuum and driven by a myriad of things, business plans, objectives, and what's going on in the world. So that's our aim, to help you manage your risk, maximize your value, and achieve commercial objectives. So today, we are going to cover a few things: why distribution agreements matter, key elements of a well-drafted agreement, some pitfalls, strategies if a distributor underperforms, social media and brand management, and then when else to seek legal advice, and a couple of final tips at the end. So it's going to be a bit of a whistle-stop tour, and I hope that I can keep you on the call. So first of all, why distribution agreements matter. Without wanting to teach anybody how to suck eggs, distributors offer a whole range of things. They're a means of expanding business into new markets, ability to navigate language, culture, and customs in different jurisdictions, along with local marketing and promotion support. The local knowledge means that they understand regional market preferences and trends and can help direct you and your brand in to places that you might not have otherwise thought of. They offer new sales channels, so they have pre-established sales networks and retailer relationships that you can tap into. They have regulatory familiarity, which ultimately means that you'll have a faster market entry and wider reach. Well, potentially, and reduce logistics burden because they'll have an understanding of how the systems work in different markets. However, if you don't have an agreement, or if it's poorly drafted, then this can result in misaligned expectations, brand misrepresentation, missed sales, regulatory breaches, all these nasty things that we're looking to avoid. So, key elements of a well-drafted distribution agreement, what you're all here for. So there are a few things to consider before drafting. Firstly, have you got a pre-existing relationship with a distributor? Do you have any informal or historic arrangements with them? It's important to consider things like prior sales, if you have any verbal understandings. This is something that I hear often, and verbal understandings, even if they're not in writing, might imply legal obligations. So without that signed contract, the distributor could still claim that they were already appointed, and with a whole lack of clarity because nothing is in writing. It's important to consider that there are also no implied obligations from emails, from trial shipments, anything that distributor could turn around and say, oh, you did engage me, and you don't have that kind of understanding of any of the requirements that you had wanted. Are there any particular peculiarities about local distribution law? These are things like regulations. In some markets, distribution is regulated differently, and some countries will provide protections to local distributors that they don't in the UK. For example, there might be mandatory compensation on termination of an agreement. That's not, if you haven't drafted that into a contract, that could be implied. And then you end up potentially being on the hook for something that you didn't anticipate. Things like organic, alcoholic, or functional products might also trigger special regulatory requirements. So it's good to think about all of these things, specific product labeling and package requirements in the different market before you start drafting your contract, just so you kind of know where you start and what you want to be included in your commercial goals, What do you want to avoid? What do you want to enable? That's basically what the distribution agreement is there for. Clarity across the board for you, for your distributor, so you can go to sleep at night knowing that everything is covered and that hopefully you're not going to wake up to any surprises. So some key considerations and clauses that you might want to think about. Firstly, protection if a distributor doesn't perform. So performance, have you outlined deadlines? What happens if the deadlines are not met? Could it be that you perhaps change the agreement from being exclusive, if that's how it was in the first place, to non-exclusive? So their performance is kind of is contingent on them meeting those targets. Then reporting mechanisms, have you baked those into your agreement, or at least thought about them when you're right from the start? So that right to kind of audit, to examine, maybe you want to go to meetings at the stores, are these things that you've considered? Because it's always worth putting those in writing if you want to follow that through later on, even if it's not something that you're thinking of at the beginning. It might be something in a year that you want to kind of fall back on. Then IP rights, intellectual property, is that protected? So it's really, really important. Your IP is such a huge value, perhaps the majority value point of your brand. So you want to make sure that the IP protections prevent your distributor from registering your IP, your domains, social handles in a country without your knowledge. So making sure that they're protected and that everyone knows how they can use them as well, like what the distributor's requirements are with your social network, and with your trademarks and with your logos, etc. Then going on to termination rights. How can the agreement be ended? How can it be modified if the relationship doesn't go as planned, or if various performance criteria aren't met? I think this is one of the really important ones. You're kind of preparing for the best and planning for the worst. So termination rights are really important because you don't know how you'll feel in a year's time. You don't know what will happen to the business of your distributor. If they're not successful, if their company isn't doing well, consider whether or not that's a distributor you want to be connected with, or whether or not you can bake in rights that say if they're undergoing any sort of insolvency procedures, for example, you're able to terminate that contract. All of the things that kind of give you uncertainty when you're in a relationship with anyone really, but particularly important to make sure that your product and your brand is protected in that sense. I think the final thing under this point is to try and make sure that UK law will apply. So this is helpful if you've got a contract with an overseas distributor. You're operating in the UK. It's not always something that you can negotiate, but it's definitely a good starting point just so that you can understand where they're coming from as well, if they're not based in a jurisdiction where you have kind of understanding of the legalities. So if you're able to state that UK law will apply, and that potentially an alternative dispute resolution option can go ahead if there are any disputes instead of going to court, it means costs are reduced, and it could mean a time frame that is more appropriate for the dispute. I mean, with all of these things, it's really good to kind of have an awareness of how they operate and how they're working for you. It's not always the case that you can negotiate these things. We get this all the time where we're engaging with other parties, and we go back and forth saying, oh, well, if you can do this, then we'll do this. And it doesn't have to be a sort of antagonistic relationship. It can be a friendly discussion with the other side, but it's really good to have kind of a starting point and know what you're willing to negotiate on and what you're not. So other things to consider, that that any commercial points are really clearly defined. So the appointment scope. So is the agreement going to be exclusive? Is it going to be non-exclusive? Might it change, as we spoke before about if they don't meet their performance targets? Does it change from exclusive to non-exclusive? Are they the sole distributor in the market, or are there others that you're engaging? I think this point, a lot of people won't have sort of options. There's going to be one person that they know that they want, but it's still worth bearing all of these things in mind, even if it's just one distributor that you want to target. Have you laid out territory requirements? Make sure they're specific and enforceable geographic limits, so that so that everyone is clear on that market and what the scope of their reach is. This is also important with e-marketing as well, and making sure that that's defined and where they're using sort of their online reach. Your products, what's included, and can you launch new ones freely? That's always good to make sure that you're able to, you've got control over the other products that you might want to bring into the market. Then with pricing terms, with payment, make sure that that's all really, really clearly defined, so you know what you're getting when, what they're getting when. Nobody is unclear as to when they're getting paid. Are there bonus incentives for overperformance? Do you have a payment schedule set so that, again, everyone's clear? Do you have a set or recommended payment or costs of products? Who handles the discounts and promotions? Is it you? Is it the distributor? All of these things that may well be kind of whirling around in your head, or that you assume are understood by everybody. Good to get these somewhere in writing, just so that everyone knows what's going on. Then a couple of other things. I mean, I think this is probably one that people will be fairly well aware of now after COVID, which is force majeure. So this clause ensures that you're not on the line for something that you can't control. Some contracts draft it as an act of God, but these are things that you don't want to be on the line for. If COVID, God forbid, happens again in some form or other, you want to make, as far as possible, make sure that you're not on the hook for supplying a whole load of product to a distributor that you're actually not able to do anymore because of reasons outside of your control. Then making sure that everyone knows what their regulatory responsibilities are, and that can be sort of having a conversation with the distributor and just getting an understanding of that market, and what they're happy to take on and what they're not happy to take on, so that you're not arriving at customs and realizing that there's a whole load of things that you thought the distributor was going to do that they thought that you were going to do. So it's all of these things that we're just trying to mitigate. So a few common pitfalls that we are trying to avoid is vague or overlapping territories. So I've commented on this before. Lack of clarity, confusion, reluctance to invest in promotion of things that can happen when there's vaguity, and people don't know what's going on, and what the online sales boundaries are. Making sure that you have your minimum and really clear performance target set as well, so that everyone knows where they stand. It's really important, this, actually, because without targets, there's no contractual obligation for distributors to actually push your product. It's you know, of course, it's done on trust and respect, and you really hope that people do what they say they're going to do, and they've got a reputation to uphold as well. But sometimes you don't know what will happen, and you don't know what opportunities are around the corner for the distributor. So you want to make sure that your brand is a priority for them. And so using terms like best efforts, that's something that's often found, can be quite difficult to enforce, just because it's just quite difficult to define what best efforts mean. And we always find things like reasonably as terms that can end up actually being quite vague. So we try and avoid using those words when we're drafting agreements. Other pitfalls, you lose control over your brand, the brand use, or there are unclear guidelines. So so the distributor isn't quite aware of what they should and shouldn't be doing or saying in relation to your product or your brand. And this can, I mean, this can obviously have huge knock-on effects if your brand is being sort of misunderstood or mistranslated in a different market, or used on channels that you hadn't anticipated, and both sort of digital and physical challenges. So as well, weak or missing termination clauses. I mean, we've spoken about termination, so I won't go into this too much. But if you get shown a contract, have a quick run through it, have a look at the termination clauses, have a look and see if it's mutual as well. If you're able to terminate for any reason, if they're able to terminate for any reason, this can be on notice, so it's not necessarily that they turn around and say we're cancelling the contract, we're ending the contract tomorrow. There might be notice requirements, so that might be 3 months, that might be 6 months. You can decide what that is if you're drafting the agreement from the start. But it's always good to know on what basis the contract can be terminated, and making sure that it's not what we call evergreen and just rolling on interminably without any review points. That's not necessarily ending the contract, but it's good to say after the first 3 months in the market, after the first 6 months, whatever it is that you feel is appropriate, that you might have just an opportunity to review, see how things are going, see if there are any things that you want to change, check in with your distributor, make them sort of understand that you're engaged in the process as well. So we find with these kind of agreements, it doesn't always have to be sort of the big bad wolf coming in with a legal document. It's hopefully there so that everyone is kind of comfortable and happy with what's going on. And sometimes it's a good pause for thought if people don't want to have things in writing, and they don't want to agree to things in that sense, whether or not that's a slight alert to potential future problems, because really it shouldn't matter whether or not it's in writing to somebody who's going to sort of follow the requirements anyway. That's just something that I think about. And so another couple of pitfalls: misalignment with marketing strategy. Again, good to make sure that brand guidelines are followed, and this is in relation to marketing strategy as well, where everyone knows what's happening. Distributors might push products in the wrong channels, might ignore your key messaging, brand tone, positioning, especially on social media, which has obviously got an increasing reach. So it might be that you want to create a marketing plan, have brand guidelines, send that across, make sure that that any changes to that are sent across as and when they change. You know, it's a continuously evolving landscape, so it might be that you have kind of quarterly check-ins to make sure that marketing and branding is all on track. And also if things change in other markets as well as they're bound to, that you're up to date with what's going on that side, and it all aligns with what you're aiming to achieve. So we touched on this as well. If you don't put any audit or reporting rights, you will have limited visibility into your distributor's activity. And we love data. We want to know what's selling, what's not selling. So all of these things are good to get written down. And that you have the right to audit records as well, so you know where you stand. So we've got some protections on if it happens that your distributor underperforms. And I think these are things that is always good to know, even if your distributor is doing wonderfully well. It's best to be prepared, because it means that you'll be more flexible and you'll kind of be able to notice the signs more quickly. So first of all, I'd say be wary of immediately switching distributors. It's one of those kind of take a breath moments. It can be really time consuming and costly to immediately switch, just because then they're not kind of complying with the contractual agreements or the performance that you'd hoped. So these are things that I'm sure many of you will be aware of and are doing anyway, but just things like, are you supporting them with advertising and promotional funding? Do they have enough training? Do they know enough about the product to actually meet the targets that you've set? Have you built relationships with other in-market experts? Are you able to get a bit more of an understanding outside of that local distributor, just so that you can go into any meetings with a bit more knowledge? Are you communicating regularly? Are you using the appropriate tone based on the market that they operate in? I think this is one thing that's just across the board. Regular communication is so important for those relationships where people are kind of going off and doing their thing in their own market. It's good to kind of have those regular check-in points, so that everyone knows that they're remembered. And their expectations are aligned. I think you can sometimes end up distancing those expectations if you're not spending kind of time building those communication networks. And those are the points where things start to break down, often when communication has broken down. So a second is legal enforcement. If it comes to that point, if you've really struggled with your distributor and you've done all of the things that we've just spoken about, whether or not there is anything that you think you might be able to enforce, and consider remedies under the contract. Are you able to reclaim products that you sent out? Are you able to reassign the contract to somebody else? These are all things that you may or may not be able to do based on whether or not you have a contract or have written these things in the first place. Are you able to recover any damages? Are you able to terminate the contract? Are you able to compensate the distributor for an early exit from the contract? So if you decide actually it's a no-go, we can't continue, are you able to, do you have the funds to compensate them? You put something aside for that eventuality. And then alternative dispute resolution, which is not always an option based on the jurisdiction you're in, but certainly in this country it's the heavily preferred and often the required first step, so that you don't end up involved in costly court disputes. And even as a lawyer, we're always advising that people try and stay away from court where possible, because it can be a really protracted process, and there are many ways of avoiding it. And yeah, it just, I mean, as people will know who've experienced it, it's difficult in many ways. Have you got a contingency plan? Do you have an exit strategy? Is there anybody else that you might want to work with? I mean, this is what's so brilliant about the FDEA and the network, is that there's so much shared knowledge. So it's good to kind of tap into that as well and make sure that you're not limiting yourself, and that you're using all of the wealth of advice of people who've been in these markets already. Have you got a non-exclusive backup? So if you have a contract with one, is there somebody else that you could engage on a non-exclusive basis, either while it's not going so well or while you're trying to extract yourself from one relationship? And have you thought about a trial period and putting that into the agreement as well, so that you can kind of see the lay of the land and work out that relationship and build those new bridges? This one, obviously, like a bit more tricky. Are you able to take over distribution? That's obviously something that's not going to be an option for many people, but something to sort of consider in the short term if it's really, really not going well, with your distributor in that particular market. Are you able to transfer to e-commerce for a bit, business to business? These are just other things that that we often think about when things are not going so well. Just kind of trying to cover all the options. Even if you say no straight away, it's good to just kind of tick those off so you've thought about them, and have that temporary or emergency marketing campaign strategy in place. Obviously, these aren't kind of legal things, so to speak, but we're conscious to kind of share these as far as possible, so that it all becomes relevant in a legal context, but even if it's not sort of directly obviously relevant. So that sort of covered off that first bit about distribution agreements, and I've seen there are a couple of comments in the chat, but perhaps I'll come back to those a bit later. So I know this was also something that was touched upon in the wonderful networking event last week. So it's sort of a recap for those who were there, and perhaps something new for those that weren't able to attend last week. So for your social media and brand promotion, these are also things that you can have contracted, but things to be aware of, the roles and responsibilities of the influencer, of the distributor, of you on the ground. Do you have a social media policy? Who will be creating content? Will it be you? Will it be the distributor? Will it be somebody else completely? Do you have an approval process for it? And how frequently are you or the distributor or the influencer posting? It's all of these kind of things that you want to bake into those roles and responsibilities and have that guideline so that everyone's clear. And I think with branding, it's becoming such a huge part of people's businesses, and whether or not you've engaged influencers already or have been working with, I don't know, celebrity partners or other brands, just making sure that you've done your kind of due diligence and that all of those people are reflecting your brand, and they're aware of when to report any complaints or crises to you as well, so you don't end up in a situation where they're kind of handling customer complaints and it's totally outside your knowledge or control. So making sure you have those guidelines in place as well, so that those people that you're working with know what to say and know when to refer it back to you. Rules and regulations. I mean, this is something that we encounter often. The Advertising Standards Authority is very hot on noticing things that don't comply with their regulations, but what we say is don't always expect the influencers to be up to date with those, and so this is partly your responsibility to make sure that you're aware of what's going on, or if you don't know what's going on, you're welcome to ask me. But any misleading advertising can obviously lead to really sort of a varying range of penalties, financial or otherwise. And you don't want to be kind of hit with one of those because an influencer that you've engaged hasn't been aware of what they should be doing on their post, whether that's the sort of hashtag ad, or just making it really clear what it is that they're promoting and under what context. And with the same sort of similar vein, you want to also make sure that there's protection of your IP. So they know what they're able to use, what they're able to not use. They're not using your logo or brand in relation to another product. They're not using it in a way that doesn't support your kind of your mission, your brand promotion. And they know what's theirs, what's not theirs. It's kind of within their nature as content creators to get creative about content. And so that's particularly important that your logo, they know where, what colours, and what sort of circumstances to be using those in, so that you have full ownership over what's happening. And I mean, as we heard last week as well, social media platforms and trends evolve so quickly and are so different in different markets, that it's important to be reviewing and updating your marketing guidelines, your brand guidelines, any contracts that you have with influencers or celebrities or anybody who's promoting your brand, to make sure that you know which social media platforms that's happening on, and how they're using, and also that you're using them to their full extent. I mean, things like TikTok Shop didn't necessarily appear out of nowhere, but I think a lot of people weren't aware of the extent to which you could use it to sell products. And we've supported people drafting agreements for influencers on TikTok Shop in itself, and I remember it coming in, and various colleagues had no idea that it even existed. So these things are changing so frequently. It's important to check in and review and make sure that everything is reflecting those changes. And that different markets will require those different strategies, because of their vast different social media channels, and whether that's speaking to the appropriate legal representation or your distributor, or market experts, to make sure that those different markets are getting the kind of the support that they deserve for those different strategies, because some will require significantly more different choices than others. So I also thought that it might be useful just to point out a couple of other opportunities where it might be good to seek legal advice or advice from your market experts. It's all of these are things that lawyers can help you with, but also there's a whole range of experts that can support you on these different points. So it's not just distribution agreements. It's also when you're selecting your export market, things to consider there, and reviewing free trade agreements, making sure that you know what's happening in the different markets. As I've touched on, protecting your brand and products, your IP, product labeling and claims. I mean, this is obviously something that's very close to people's knowledge point at the moment, because things are so changeable and different in the different jurisdictions. Again, negotiating with distributors, agents, and retailers. It can kind of cross lots of different levels of the process when you're signing up to new retailers, if you're distributing your products yourselves in the UK or elsewhere. Building those cross-border e-commerce opportunities as well. Important that you've got all of the correct documentation on the website. Consumer law is quite specific to the different countries. So making sure that you're aware of what kind of consumer rights are in relation to your product and the way that they're using your website. Things like terms and conditions and privacy policies and GDPR and all of this kind of thing is good to kind of have a general understanding about before you start. Logistics and export documentation, so you're not stuck at customs with the incorrect pieces of paper. Sustainability, health or ethical certifications, and how these are changing in the EU and elsewhere. Important to kind of keep on top of that, and that's definitely something that that you can get support from in market experts. Dealing with trade disputes or non-payment, that's something that we encounter often. And as I've said before, it doesn't necessarily mean lots of money and going to court. It could just mean drafting the appropriate letter that says the appropriate things in the right way, and an understanding that it doesn't have to turn into a big argument. And I think it's also important that some of these things could have positive effect. We saw last week Roe from Kilburn and Strode talking about the brand battles with Colin the Caterpillar and various others, and how they managed to transform a kind of legal dispute into something quite positive for the brands. And then expansion into complex markets. There's no expectation that anybody knows what's going on in a market that isn't their own. So getting some help at that stage is good, a good place to start. So these are things that we can help with, or we can also navigate you to the correct person that might be able to help in a different jurisdiction that isn't the UK. Generally, we operate on English law, but we've got a network of lawyers all over the place that might be able to help. So just some final tips. Just if you're not going to do anything at all, these are things that I would recommend. Register trademarks before entering a market. Just because you've registered a trademark in one jurisdiction doesn't mean that it follows through to another one. Start perhaps with a non-exclusive and a short-term contract, if you're able to, so you can test the water with a distributor that you don't know. Have all of those conversations. Try and if it's not in writing, try and bring up all of the things that we've discussed about, just so that you really can get an understanding of who you're working with. And obviously these relationships are important to foster. And if you are wanting to get something in writing, then focusing on trust and building that relationship beyond it just being on a piece of paper is important, that it's all integrated into that relationship, and that everyone's transparent about what their goals are and targets. And yeah, in writing where possible, so that you're able to enforce anything were it to go wrong. And then finally, be prepared to walk away if the terms aren't right. If you get a funny feeling about somebody, if you get a funny feeling about a contract that you're being asked to sign and you don't just agree to it because you feel like it has to be agreed there and then. Most things can be negotiated to a certain extent, or if they can't, perhaps that's just an opportunity to think about whether or not they're the right person to be working with and supporting your brand. And that is all from me. So here for any questions at all.
Thank you, Ella. That was great. Lots of stuff to take away and consider. Appreciate a few people have had to jump off already, but if there are any questions who are still on, just please fire away. Just take yourself off mute if you've got a question for Ella before we finish up.
No questions, really. That was really, really useful. So thanks a lot, Ella. Actually, no, sorry, Ella, I do have a question. With bear with me, sorry. The arbitration, am I right in thinking that we have to specify it in a contract, but do you have to specify where the dispute resolution would be received, if that's the word? Like, do you have to specify a certain place? Like, for example, China, would you then specify Hong Kong as the place where the dispute would be dealt with?
So these are different in different jurisdictions, and it's actually changing in the UK. Before you had to specify the kind of the body that you were going through. Now you don't have to. It's something that is good to do because you don't want so that you don't end up in arbitration procedures in somewhere totally irrelevant to where you are and maybe more convenient for the distributor. It's always good to consider where would be best for you to have that process. Probably the UK to start with, or wherever you're kind of based as a starting point. I mean, I've been involved in contracts recently where a middle point was chosen because both parties didn't wanted to have a sort of fair option, and they decided that the most fair option would be somewhere that wasn't either of their jurisdictions, which caused us certain question marks that it's like make it more difficult for everybody instead of easier for anybody. But yeah, I mean, I think depending on the nature of the contract and the value, and whether or not the parties want to kind of get it over the line, your sort of strength of negotiating is there. But you don't necessarily, and certainly in the UK, it's not necessary that you do specify the location, but it's always good to do.
Sure. Okay, understood. No, thank you.
You're welcome. Nice to meet you, Alex.
Yeah, likewise.
I was just wondering, for good practice, sort of how often should you revisit your contracts? Is it sort of, particularly when you're putting in things like targets, because obviously they do change quite often.
Yeah.
So what would the sort of be a good practice sort of recommendation for revisiting contracts?
I mean, I think that can sort of take two angles, whether or not that is a time frame or based on changes in your business. I think those are two ways that you could go about it. And I mean, I think annually is a definite point. If you're expanding into a new market, that might be a good opportunity to see what's going on in the contracts that you have with others. I think it sort of depends on your strategy as well, and whether or not, and also there's kind of time and resources that it takes to review these things. But if there are big changes happening or potential future changes to the business or branding, then that's always a good place to check in. But definitely annually, if not every sort of 6 months, is a starting point.
Great. Any further questions from anyone? No? Well, thank you so much for your time this morning. Thank you, Ella. Thanks everybody for attending. And like I said, I'll be sending around Ella's contact details. So if you've got any further questions, you can get in touch. Also, the recording will be on its way to you probably later on this afternoon. Yeah, all that's from me then. Say goodbye and thank everybody again.
Thank you very much, guys.
Thanks, everyone.
Thank you.
Bye.
Bye.